Tony DeWitt here, Missouri appellate attorney, retired. None of what follows is legal advice. I'm here to do some video for you today to talk about an interesting subject on the law, and here it is. Mahari Okbu et al. Versus Amazon Incorporated is the case we're going to discuss today. It's an Indiana case that deals with an issue that has flummoxed law students forever, including me when I was a law student. It deals with the issue of duty, among other things. The Okbu case was decided by the Court of Appeals in Indiana on September 27, 2024. The case revolves around an accident involving a truck driver, the layout of an Amazon fulfillment center, the signage around the Amazon fulfillment center, and the legal responsibility of landowners for injuries sustained on an adjacent public property. It is a thorny case with thorny issues, and the result from Indiana, which is a fairly conservative jurisdiction, is a little surprising. Now, before we get started, it's good to have a view of what this layout is like, and for this we turn to Google Earth and their great program Google Earth Studio, and here you have a look at the facility. And now, as we orbit around the facility here, you can see how many of those trucks are there. I mean, this is a place that had a lot of trucks. And then if you look out here on the far right, you'll see a truck that is parked alongside the road there, or perhaps it's just not moving fast. But in the middle of that lane is what we call in the South a suicide lane, a turn lane that allows you to go either right turn or left turn from the middle. And that is where the truck parked in this case, and the driving lane to the right is where that accident occurred, where the truck driver was injured in this case. So as you can see, this is a pretty doggone huge facility, and Amazon obviously knew what was going on. The legal issues in this case are, first, whether there was a duty of care, whether Amazon, as the landowner of the fulfillment center, owed a duty of care to a truck driver who was injured after leaving his truck on a public road. Well, that almost doesn't seem fair, does it? That the accident happened on the public road, but you're going to hold Amazon responsible for it? But bear with me, I think you'll probably figure out that this is a good ruling. Premises liability. Whether Amazon's actions in maintaining its premises, particularly its entrances and its signage, extended beyond the property and created a dangerous condition for individuals on public roads. So, for example, if you have a big bushy tree that sits right at the corner of your property and it obscures your ability to see to the left as you come up to the stop sign, then there is a potential for you to be liable if somebody gets hit there because your property is creating a dangerous condition on the roadway. Now, that's not the law in every jurisdiction, but that does appear to be the law in Indiana. Foreseeability is another issue. Foreseeability always sounds like people are trying to play, Karnak, the character that Johnny Carson played on The Tonight Show, probably long before many of you were born. But basically, it sounds like you're trying to predict the future, and to a certain degree you are. But there are things that everybody sees that when they see them, they realize, that could hurt somebody. And that's essentially the question here, whether a reasonable person looking at this situation and having knowledge of some of the other incidents that have occurred there might reasonably foresee that somebody could get hurt. So here are the facts of the case. In September of 2022, Mahari Okbu, a truck driver, was en route to deliver goods to an Amazon fulfillment center. The facility had 3 entrances, but confusing signage and a lack of lighting made it difficult for drivers to identify the correct entrance. Now, this was the first time he had ever been to this facility. As Okbu drove toward the facility in the early morning hours, he encountered 2 entrances marked no trucks, but saw no signs pointing him to the appropriate entrance for him to take his truck into the facility. So, because the county road that this Amazon fulfillment center on was narrow, had almost no shoulder, he stopped his truck on the county road in a turning lane across from the facility. And then he exited his truck to go walk into the facility and find out where he was supposed to go. But after exiting his truck, he was struck and seriously injured by an oncoming vehicle driven by a guy by the name of Bruce Gibson. Amazon employees later confirmed that truck drivers regularly became confused and exited their trucks on the road in that spot. Now, the plaintiffs, when they sued, they filed a lawsuit against Amazon alleging negligence. And negligence requires you to prove there was a duty of care, that someone breached that duty, and that you were injured as a direct or indirect result of that. Here, Okbu argued that Amazon owed him, as a business invitee, a duty of reasonable care. He claimed that Amazon should have provided clearer signage and lighting at the facility to prevent the confusion that led to his accident. And in terms of foreseeability, he pointed to the evidence that Amazon was aware of the issue. Multiple Amazon employees stated that they regularly saw truck drivers get out of their trucks in the same spot because they were unsure of where to enter the facility. Now, the defendants, on the other hand, filed a motion for judgment on the pleadings, which is very similar to a motion for a judgment, or for motion to dismiss. But basically, instead of being a dismissal, it becomes a judgment, not a dismissal, because a lot of times you can get a dismissal will be for without prejudice, so you could replead it perhaps. But in this case, they gave him a judgment on the pleadings. Amazon claimed that it did not owe a duty to protect Okbu from being struck by a third-party motorist on a public road. Their argument was pretty simple. Look, the guy's on a public road. He's in the middle of the turn lane, and he gets out of his truck. What did he think was going to happen? He's walking right on the roadway. You know, we are all told when we're kids to not play on the roadway. And so the company emphasized that the accident happened in an area where it did not have control over the road. In other words, this didn't happen on the road inside the Amazon property, which is a private road. It happened out on the public road. And so their view was, hey, we don't have a duty to control drivers on the outside of our property. What's wrong with you guys? The proximate cause issue was also an important one. Amazon argued that even if a duty was owed, its alleged negligence was not the proximate cause of his injuries. It alleged the proximate cause of his injuries was the driver who hit the guy. And, you know, they're not responsible for that driver. It wasn't their driver. Amazon shouldn't be held responsible for that. So there were fairly reasonable arguments on both sides, and I'm sure this was a tough case for the court to get to. Now, the trial court initially ruled in Amazon's favor, granting its motion for judgment on the pleadings. But the Court of Appeals in Indiana reversed the trial court's decision. The appellate court held that Amazon did owe a duty of care to Okbu and that the case should proceed to trial. And here was their reasoning. The court reasoned that a landowner's duty of care is not limited to their property. And they pointed to a case from their court called Lutheran Hospital of Indiana versus Blazer, where the court held that a landowner can be liable if its actions created a dangerous condition that extends beyond the premises. And in that case, the hospital had an exit from the hospital, and there was you could walk right across from the exit into the parking lot. But in order to do that, you had to go through a exit lane where people were coming in. In other words, you had to cross an area where cars drove routinely. And it wasn't always clear that that was a dangerous condition that someone would be aware of, but the hospital was certainly aware of it. And when Blazer was struck, she sued the hospital, and the Court of Appeals reversed a decision against her. So the precedent was that you can be held liable if you create a dangerous condition that extends beyond your premises. And then on the foreseeability and the duty of care, the court found that it was foreseeable that truck drivers would be confused by the inadequate signage and lighting at the fulfillment center, leading them to exit their trucks in a dangerous location. Amazon had actual knowledge of this confusion because its employees witnessed it regularly. And of course, it's inferable that if its employees saw this, they reported it up the chain of command, and somebody at the top of the chain of command thought, we don't need to change our signage. And unfortunately for them, that didn't work out real well for them. Now, the restatement of torts, the third restatement of torts, also has principles that apply. Restatements are put out about every 10 to 30 years, depending on the subject, and they basically take a look at all of the law on certain subjects and they try to categorize it and put it into an accessible format so that a court, particularly a Supreme Court, could go and say, yeah, this is what the general thesis of liability is in these cases, and we're going to adopt that, and we're going to make that the law in our state. So the restatements are not the law per se, but they are very persuasive to courts in ruling on these kinds of issues. The restatement says that landowners have a duty of reasonable care for conditions on their land that pose a risk to people off the land. The court found that Amazon's failure to provide clear directions created an artificial hazard on the adjacent road. Now, the case is important because it expands the understanding of premises liability in Indiana. It highlights that a business owner's duty of care can extend beyond the boundaries of their property if their actions create a foreseeable risk of injury to individuals on adjacent public property. One of the judges in a companion case that was issued the same day actually asked the Supreme Court of Indiana to adopt this restatement provision so that it became the law of Indiana. In other words, while this applies, while the Court of Appeals here is making this decision, it believes that the judge believed that it was more important and that it should come from the state Supreme Court. And that is pretty much the significance of the case. In conclusion, the Court of Appeals held that Amazon owed a duty of care and that its invitee was injured as a result of their breach of that duty of care, and the case should go to trial. The decision is significant, as I said, because it clarifies the responsibility of the landowners. When they have conditions on their property that create a danger outside their property, in other words, blocking the view of a public roadway, or a tree that overhangs the road and might fall and crush somebody's car, for example. These are the kinds of things that can create liability, even if the accident happens on the public road. So that's what I have for you today. Hopefully you found this interesting. May only be interesting to the people in Indiana, but I still think it's an interesting case. The court, I think, analyzed this case absolutely appropriately because absent the failure of Amazon to properly sign its entrances, in other words, not having a big lighted sign that said, this is where you enter the property, that created a huge problem for these drivers. And there were two of these cases that got to the Court of Appeals at almost exactly the same time. So that tells you that this was an ongoing issue and something that Amazon should have dealt with a long time before. And you can buy law books from Amazon, so maybe Amazon ought to be, consuming some of its own content. That's all I'll say. And by the way, I use Amazon all the time. And I hope that when those guys were going in there, they weren't getting something to ship to me. That's what I hope. So thank you very much for watching. If you have an opportunity today, go out of your way, do something nice for somebody. And if you have any comments, drop them in the comments down below or email me at the address above. And when you're done doing that, come on back tomorrow, join me down here at the beach, and we'll talk about something else. Hey, as I said at the beginning, none of what I said is legal advice. But let me tell you what. The stuff that's going to be right up here, these are the things that YouTube thinks you might be interested in going forward. Have a terrific day.